All right, everyone, welcome back. We are going to start our next session of the Helping Nonprofits COVID CLE. And now I'm very excited to introduce Heather Culp from Essex Richards, who's going to be talking to us about bankruptcy and some bankruptcy basics. And I will turn it over to her. Thank you, Heather. And also, like all of these, if you have any questions, just put them in the chat. And at the end, I can funnel the questions to Heather, or if there's something that seems appropriate, I might interrupt you, but generally we've been waiting until the end. So thank you.
Thank you. I regret that we can't see each other and interact in a more personal setting, but I'm thankful for this platform and for the opportunity to talk to you all today about a corner of my practice area that I think is really rewarding, whether you're doing this on a pro bono basis or not. This is an area of the law where you can see a real, tangible, instant benefit for your clients. And sometimes, you know, that's delayed. So without further ado, I thought I would tell you just a little bit about me and my background to kind of orient you to the experience that I bring to this today. I've been practicing law for almost 23 years. I practiced for 5 years up in Kentucky out of law school. And then the rest of the time, I've been practicing here in North Carolina. For probably the past 15 years at least, a significant part of my practice has been in the bankruptcy and other debtor-creditor relations in those two areas. I have represented debtors. Obviously, those are the people who are filing for bankruptcy. I have represented creditors, and I have represented trustees. And trustees are those who are appointed by the court to administer and oversee bankruptcy cases. The majority of my practice, at least up until about 2 years ago, was representing debtors. And to be a little bit more specific and put a little finer point on it, I primarily have represented consumer debtors. And what that means is basically people, individuals and married couples, not businesses. About 2 years ago, I was appointed to the local Chapter 7 trustee panel. So now I regularly rotate in and out and am appointed to administer Chapter 7 cases. And I'm also panel counsel for Lawyers Mutual. If you happen to have a claim against you or a threat of a claim against you in the Western District of North Carolina in a consumer bankruptcy case, odds are good that I will be helping you with that. So with all of that background, here are the things that I would like to share with you today. Get my PowerPoint to advance. Give me just a minute here. There we go. I think, you know, this audience probably know what bankruptcy is. It's technically a legal process. You can see that here. It's what happens when you file a bankruptcy case. And cases can also be filed involuntarily. Creditors can file cases against an alleged debtor, but that is so rare that it's not worth talking about today. I like this quote here. It's a ubiquitous quote that we see a lot, particularly in the consumer bankruptcy world. And I think it's a good way of explaining what bankruptcy is all about. It's about giving good people who have tried their very best to pay their debts on time and as they become due, but just can't. And as I tell my clients, the flip side of that is, you know, a debt that you owe for some sort of a nefarious purpose, and we're going to talk about what those nefarious purposes are today. That debt may not go away, but most types of debts are going to go away in a bankruptcy, at least the client's personal liability for those debts. Chapter 7 is a liquidating bankruptcy, and we're going to focus on Chapter 7 today. That's probably the most useful for this audience and for nonprofits and pro bono agencies. You can see here at the bottom of the slide that Chapter 7 is a liquidating bankruptcy. Some people call it a straight bankruptcy or a simple bankruptcy. What it really means is the debtor is not making monthly payments to a local bankruptcy trustee for the benefit of creditors. It means that the only way that creditors are going to get a payment from the bankruptcy court or through the bankruptcy system in a Chapter 7 is if there are assets to liquidate. If the debtor has something above and beyond what we're all allowed to keep safe from our creditors, then that can be liquidated and used to pay creditors. And we're going to dive into that topic, you know, in much more detail today. I would say for now, it's important to understand, and I think helpful to know, that the vast majority of Chapter 7 cases, at least for individuals and married couples, are what we call no asset cases. And that's what it sounds like. It's kind of the best of all worlds, but also the worst of all worlds. What it means is the debtor has, so little property of value that it's not going to be taken from them. There is nothing to be liquidated to pay creditors. And that's good. That means the debtor is going to get rid of their debts. They're going to discharge their personal liability for their debts, but keep their stuff and be able to move on. This is a big topic to cover in an hour. So I thought I would kind of start here with explaining what we are going to cover, or what I hope to cover today. And in thinking about how to do this today, knowing we had a fairly limited amount of time, I have two goals, and I wrote these materials and put this together with two goals in mind. One is to give you folks a basic overview, a pretty high level overview of how Chapter 7 bankruptcy works and what it can and cannot do, and who it can help, just so that you can issue spot. A lot of times, particularly for nonprofit and pro bono agencies who are, taking calls or taking intake, all they need to do is, and it's not simple, but to be able to look at a client's circumstances and know, yes, this is something that we can help with or not, and then know to refer it to a Chapter 7 attorney. I guess the second goal today is, if you are, as a volunteer attorney, are interested in filing Chapter 7 cases pro bono, I'm going to give you some of the practical tools, hopefully, that you'll need to get started in that. I don't think it's a great idea to dive in and file Chapter 7 bankruptcies based on this 1 hour seminar, but hopefully you can get your feet wet, and I will point you in some additional directions where you can go to learn more. So let's talk about the main relief that a Chapter 7 bankruptcy can provide. There are other types of relief, but I think that this slide hits on the most important ones for today. One of the benefits is the automatic stay, and you can read about that at 11 USC 362B. For those of you who don't know, the bankruptcy code in its entirety is at Title 11 of the United States Code. So I'm not going to say 11 anymore, or Title 11. All of these citations are going to be to Title 11 unless I say otherwise. What I tell my clients, pro bono or not, is that the automatic stay is automatic. That's why we call it that. The minute a bankruptcy petition is filed, and to put a little finer point on it, this assumes, for purposes of today, all of this assumes that this is a voluntary case, that individuals or married couples are choosing to file for bankruptcy. The minute that petition is filed, the automatic stay goes into effect and stops most types of collection activity. And this just provides immediate relief to people. Generally speaking, the automatic stay is going to stop levies and garnishments, including from tax authorities. It will stop lawsuits. It will stop depositions. It will stop attempts to collect. It will stop collection calls. If someone has a judgment and is trying to execute on that, it's going to stop that. It is very broad and very extensive. Item 2 here is that a bankruptcy provides an orderly, predictable resolution of debts in one forum. And I think the point there is it takes a chaotic situation, what is often a chaotic situation, and makes it manageable. I think it's our job as attorneys to tell our clients, what their options are, the pros and cons to each, and those options are going to include a bankruptcy, how that works and what to expect. Most people, in my experience, regardless of their income or educational level or background, they're scared witless by the time they come to my door. Things are behind. They're getting collection calls. Sometimes their family members are getting calls about debts. They're getting sued, they're getting papers from the sheriff, they're getting writs of execution. This may be going on in multiple jurisdictions, and it's just a very frightening time. And generally speaking, I can tell people, here's what a Chapter 7 will do for you. Here's how it will help. Here's how long it's going to take. And here's where it's going to end up. And I think it's our job, to minimize surprises as best as we can and guide people through this. Most importantly is the discharge of a debt, number 3. That's the whole goal of a Chapter 7 bankruptcy case for an individual or a married couple. The goal is to receive from the bankruptcy court a discharge order. And that is a simple one-page order that says that you, debtor, it'll have your name on it, you've done everything that you are supposed to do, and your debts are hereby discharged. And on the back, there's some explanation for lay people about what that means. Basically, what it means, to the extent that they are the types of debts that are discharged that go away in a bankruptcy, they can no longer be collected from you. And obviously, that's an example of why there are lawyer jokes, to the extent that they're the types of debts that are discharged, they are discharged. We're going to go into some detail about what that means today as well. Generally speaking, a discharge is very broad. Most types of debts are dischargeable in a bankruptcy. And I have some examples down here on this slide. And we'll tell you that 523A is the exclusive and exhaustive list of the types of debts that can survive a Chapter 7 bankruptcy. Fairly early in my career, I would spend some time spinning my wheels. I felt like something felt like it shouldn't be dischargeable. It felt like it should survive. If it's not on that list, it doesn't survive. And I think the most relevant and useful example of that today for this audience's purposes is Social Security and unemployment benefit overpayments. At any given time, I have a client who, through no fault of their own, received more unemployment or more Social Security disability benefits than they were entitled to. For example, I have a client right now who was referred to me by a local pro bono agency. He applied for Social Security disability. His application was approved and he received disability benefits. There was a subsequent hearing at which the administration determined that he was no longer disabled. And at that point, the benefits stopped and he got an order requesting him to pay back $35,000 worth of benefits. They decided that he was no longer disabled, retroactively at a point in the past. Well, this gentleman will never be able to pay that money back. And it seemed to me that maybe that was the type of debt that would not go away. But in fact, it is dischargeable. Going back to that quote earlier about bankruptcy being available for honest people who've done their very best and can't pay, what that means is, you can't be dishonest in incurring a debt and have that debt go away. So just to contrast that, I've had clients over the years, who have applied for unemployment benefits when they were actually employed, or applied to continue receiving them after they regained employment. And what I tell them is, you took affirmative steps to misrepresent your situation. And there's a chance that the creditor will file a lawsuit in the bankruptcy and ask that the discharge of that particular debt be denied. Everything else will go away, but that will stand. So that's a little bit of information about how a discharge can help, a Chapter 7 discharge. It occurred to me in looking at these slides today, just before joining you all, that I probably should have added to number 3, kind of in bold or in italics, that in certain circumstances, income tax is dischargeable in a bankruptcy. A lot of people are surprised to hear that. A lot of lawyers are surprised to hear that. That is a pretty complicated area of the law, and I'm not going to go into it too much today, but just squirrel away in the back of your mind that if the circumstances are right and the taxes are old enough, they generally have to be 3 or more years old, looking at the date of the bankruptcy filing. Then whether it's federal, state, or local income tax, those taxes could possibly be discharged in a bankruptcy. This next slide here is an overview of the relief that a Chapter 7 bankruptcy cannot provide. Just to touch on this, I would say that number 1, Chapter 7 is not an arena for restructuring or reorganizing debts. You're either going to discharge them or you're not. If a client, and I think for our purposes today, this is unlikely, but if a client could benefit from a restructuring or a reorganization of benefits, then there are chapters in which that relief is available. The primary one is Chapter 13. I do Chapter 7 and Chapter 13 all day, every day. Chapter 13 is a personal reorganization. It's available for individuals and married couples. There are a variety of eligibility concerns, but the primary purpose of it is to restructure your debts. It's a personal reorganization in which you propose a plan under the bankruptcy code to handle your debts in a bankruptcy. And one of the main reasons for filing a Chapter 13 bankruptcy is to stop a foreclosure or to catch up on a mortgage that's in arrears. You can do those kinds of things in a Chapter 13. That's not available in a Chapter 7. Chapter 13 involves monthly payments for 3 to 5 years. And as we've talked about earlier, Chapter 7 does not involve monthly payments. So it's just not an option there. The other thing I think that's worth touching on this slide is number 2. There is no chapter under the bankruptcy code that allows individuals to modify or discharge a domestic support obligation. That includes child support, alimony, maintenance, and other debts that are in the nature of family support. Up until the law changed in 2005, there was some room to maneuver there, but that's just not an option anymore. So if you're an agency or an attorney who gets an inquiry and that's the main problem, this is not the forum to take care of that. I will add number 3, relief from equitable distribution or property settlement debts. Those debts are dischargeable in a Chapter 13 bankruptcy. And that's as far into that as we need to go today. Number 5, lack of income. Sometimes I include this when I'm giving this type of presentation and sometimes I don't. I thought it was worth including here because I would say for, probably 90% of my Chapter 7 clients, they're going to get instant relief from a discharge order and things are going to get a lot better. They have good household income. They're, relatively young, have some earning years ahead of them. They have some retirement savings. There's just some good reason to know that things are going to get a whole lot better, that, 1 or 2 bad things have happened or 3 to bring them to this circumstance, but it's going to get better. But I will tell you that, 10% of my clients, they kind of keep me awake at night. I worry about them. Things are not going to get better for them. We can get rid of the debt that they have or most of it, but they're never going to have the income, or at least it's unlikely that they will, to live a decent life. I have referrals from pro bono agencies and I just take people who call here needing help. I'll help them pro bono if I can squeeze it in. It's pretty tough to be, 70 or 75 years old and living on $900 of Social Security income in a month. And that's part of what we have to talk about sometimes is, I can help you with this, what's happened in the past, but the future, I can't help you with. And if you've got friends or family who can help, now's the time to lean on them. Sorry to be Debbie Downer, but that's just something that I thought was important to touch on. What we're not going to cover today, reorganizations, we've already talked about that. For those of you who are pretty unfamiliar with bankruptcy, Chapter 11 is a reorganization. Anytime you read about a business filing for bankruptcy, they usually at least start out in a Chapter 11 with the hope of reorganizing and moving on. There's no reason to talk about that today. Chapter 13 we've touched on can be very helpful for individuals and married couples. It's a personal reorganization. It's a poor man's Chapter 11. It's very similar, but it's just a lot more streamlined and cheap. And just so that you know, Chapter 12 is Chapter 13, but it's restricted to family farmers and family fishermen. So we're just not going to get into any of that today. I think probably most of you know that at least the law now and for a long time and probably for the foreseeable future is that you cannot discharge or modify educational loans in bankruptcy. There's a test and there's some law there, but suffice it to say that it's a very high burden, and North Carolina is a pretty conservative state, and our courts that's just not where it's at. It's not worth spending time on today. I hit earlier on the dischargeability of income taxes, and I'll just say that's a substantial part of my practice. I often say if there is a hell, it's going to involve me, sitting at my desk for 7 hours reviewing IRS tax account transcripts and calculating when income taxes will be dischargeable and explaining all that in an opinion letter. It's just not something that you should dabble in. If you've got a client with income tax debt, I would say refer it to someone, who's got some experience in that area. So the screening process is kind of where we begin, and I would imagine where you folks in the audience begin. And I have seen various pro bono agencies intake materials. If I take a referral, I usually get a copy of that. And I understand that sometimes the intake needs or the information that you need to qualify for grants or to prove you're using grant money in the right way, or to make sure that the folks fit within your mission is one thing. And sometimes there's some overlap, but often the information that I need to figure out whether they're a good candidate for bankruptcy and I think I can help them is different. And these are the questions that we ask on the phone. My paralegal takes all of our potential client calls, whether they're from paying clients or from pro bono clients. And these are the questions that she asks. She just types up an email to me with a quick answer, and I can take a look at it in 30 seconds and decide whether or not I want to offer a consultation and on what terms. Point two here, bullet point two, I think it's worth saying that we ask about income right off the bat. There's nothing like being intrusive and saying, what do you make a year and what do you do? You've never met me, but I need that information. We need that right off the bat. And we also need to know if they're married, what their spouse does for a living and what they make. And as we're going to go through a little bit more detail later in this hour, there are income eligibility guidelines for the majority of Chapter 7 cases, and they are keyed off of household income. It's not just what the person who's filing for bankruptcy makes, but it's the income to the household. And I think this makes some sense. Let's say husband is making $10 an hour, 20 hours a week. If wife is similarly situated, they're going to qualify for Chapter 7 bankruptcy. But if wife is making $250,000 a year, that's quite different. And that affects husband's ability to make some payment to his creditors. So that's why we ask that question, and that's why that's important. The other question my paralegal typically asks, and I ask too during the consultation that's not on here, is there any emergency? That usually comes out right off the bat. People are usually calling because there is an emergency. They got notice of a foreclosure. The Department of Revenue or the IRS cleaned out their bank accounts. Something bad has happened, but they don't always lead off with that. And that's not always the case. Some people call, before a shoe has dropped, before it's gotten really dire. But part of our job as bankruptcy attorneys is to understand the timing factors and to react accordingly. A lot of this is timing, and it's our job to know when is the right time to file, if there is a right time, and explain to our clients how all that works. So talking about initial consultations, assuming, that I started to say invite someone in back pre-pandemic, I was pretty insistent that folks come in person for their consultations. I just think there's, nothing that substitutes for a face-to-face conversation, particularly about something that is usually an emotional decision for folks. But, one of the things the pandemic has taught me is that we can do business by Zoom and by phone, and that's what we've been doing. But regardless, however we're going to do the initial consultation, there's some materials in your in your manuscript, some written materials with some tips, but more importantly, there's some forms. And I have a form in the materials. It looks like it's form 2 on page, I think it's form 1. That's the intake sheet that I use, or the checklist I use in my initial consultations, just to, remind me of the important things that I need to ask about. So definitely check that out. And I have a stack of those in my office, and I fill them out for every single consultation and keep them. It's just a good way for me to keep track of some detail of this person's particular circumstances. Point 1 on here is to give the client or the clients, if they're married, some time to tell a little bit of their story to you without judgment. Without fail, every client who comes in wants to tell me right off the bat, I didn't mean for this to happen. I'm a good person. I've always had a good credit score. I've always paid my debts on time. But, there's a but. And what I tell people back is, basically everyone says the same thing. Everyone is a good person. Everyone did the best that they could, and just something went wrong. And most of us are paycheck to paycheck, and it can be surprisingly easy to get behind and never get caught up. So I give folks a few minutes, to tell me a little bit about them and how they got here. But it's important to keep people on track. It's really not a very good use of time to be cold about it. The purpose of the consultation is to get the specific information that you as an attorney need to evaluate their situation and make recommendations, pros and cons, and answer questions that they have. And I limit my consultations to an hour, and an hour goes by quickly. And that kind of leads to point two, taking charge. I just tell folks up front, I'm going to ask you a lot of nosy questions. And this is what I need to know to be able to help you. So, bear with me. And I'm going to jump around, and it's not going to make a lot of sense, but I'm going to come back when I'm done asking questions and explain why I was asking all of this. So these are the purposes here for the consultation, or the goals here. Briefly, I think before I started doing this kind of work, I was pretty privileged growing up, and pretty privileged now for a variety of reasons. And I just had some, I think, misconceptions, misunderstanding, and some prejudices about how people could wind up in bankruptcy. And they're just wrong. I mean, the myth that's out there that people are irresponsible and go out, go on big spending sprees with luxury goods and then file for bankruptcy. That is not my experience over the last 15, 16, 17 years. I could probably count on one hand folks who are like that. It's much more likely that one or a combination of these factors or other factors bring folks, to a bankruptcy attorney's doorstep. And I would just underscore the generosity point there. I have observed time and again, particularly for lower income people, they have helped multiple generations. They've helped parents, siblings, kids, grandkids, in any way that they can. And, when the day comes when they need help, there's often no one there to help them. So, just listen with an open mind, and I guess an open heart. This is a little bit more here about the initial consultation. It's Form 1 on pages 11 and 12 that are the loose guide that I use during my consultation. And that's just something I've come up with over the years. I didn't pull that, out of any particular form book or anything. I would say use that checklist or form, or your own checklist in a consultation, kind of like if you're a litigator, you would for a deposition outline. You're not going to read every single question. You're not going to have a script word by word. It's to keep you on track, but it's really important, I think, to ask open-ended questions, to give people the space to answer fully and completely and honestly, and to listen for what they're not telling you. A couple of examples of this are, if someone is super preoccupied with, will my mom find out about this, asks more than once, why are you worried about that? What's going on there? And there could be all kinds of answers. It could be that mom has loaned money and is being very overbearing and trying to collect it. It's weirdly enough, it's been my experience that it's often creditors who know you on a personal level who are the most harassing and trying to collect a debt. If that's the case, then we'll talk about that. If they've borrowed money from mom and paid her back, I need to know about that, because special attention is paid to money that's repaid to insiders, relatives, and close friends within the year prior to the bankruptcy filing. That's called a preference. That's just a simple example of pick up on people's preoccupations and trust your instincts and dive into that. The other tip I would say is to ask open-ended questions as best as you can. And my best example of this is personal property. If you're looking at Form 1 on page 2, which is the back of my form when I'm using it, I print it 2 sides, there's a question about personal property. And the way I ask that question is, we've talked about your real estate, we've talked about your car, we've talked about retirement accounts. I'm going to ask you now about your personal property. And personal property is anything other than real estate. And if you get into a situation where you can't pay your debts on time and in full, we don't take everything from you and make you live in the street. Everybody's allowed to keep basic property to move on and be productive. So for today's purposes, I just need to know about what I think of as big ticket items. And when I say big ticket item, what I have in mind is any one thing that you own, OWN, that you think that you could sell quickly. Yard sale, pawn shop, eBay, Craigslist for $1,000 or more. That gets them thinking and that gets them talking. We have a good conversation about what they have, and I have a good feel for, is there anything here to worry about or not? The way not to ask that question is to say, you get to keep $5,000 worth of household goods. What do you think your household goods are worth? It's more of a, real world level of talking to people. I mentioned earlier that household income can come into play in assessing eligibility for Chapter 7. And if you have any familiarity with bankruptcy at all, particularly with Chapter 7, you may be aware of the means test. The means test did not exist before 2005, but it's been part of the bankruptcy code since then. And the idea is we as a society and as a bankruptcy court want to know if people in bankruptcy have the ability to make some payment to their creditors, if they have the means. That's what the means test means. And so what that means is for individuals or married couples who are wanting to file for Chapter 7 bankruptcy, part of what we need to do is determine whether the majority of their debts are consumer in nature, whether these debts were incurred for a family, an individual, or a household purpose, or in contrast, whether they are non-consumer in nature, whether they were incurred for a business or profit motive. The way Congress set this up, agree or not, is if the majority of debts, and it's just a simple addition, if the majority of debts by 1 penny or more are consumer in nature, then household income has to be sufficiently low to be eligible for Chapter 7 bankruptcy. In contrast, if the majority of the debtor's debts are non-consumer in nature, and that includes income taxes, weirdly enough, if the majority of their debts are non-consumer in nature, they are eligible for Chapter 7 relief without regard to household income. And the reason for that is Congress wanted to encourage us to start businesses, to take risks and personally guarantee things. And if they don't work out, to be able to walk away and do it all again, because small businesses are such an important part of our economy. So weirdly enough, I have had clients over the years who have, $350,000, $450,000, $550,000 in household income on an annual basis, but the majority of their debt is business related and they're eligible for Chapter 7. Whereas, a household of one that makes $52,000, $54,000 a year, the majority of their debt is consumer in nature. They are not going to be eligible for Chapter 7. Odds are that if you're doing a pro bono bankruptcy, income is not going to be an issue, but it's just something that I wanted to point out here. These guidelines here change every 6 months. I've got here where you can look them up. And it's not as simple as this. Congress, for example, wanted to encourage us to borrow money for secured debts for which there's a collateral, and to honor those debts and not be penalized for it. So if you've got a mortgage payment and you want to continue paying your mortgage, if you've got a car payment and you want to continue paying your car payment, you get some credit for that. So your income can actually be higher than this under some circumstances. But again, it's another example, I think, of poor people being penalized. Most of the pro bono clients that I have, they've got a car that's paid for, they're renting an apartment, they're not going to get any breaks on their income. And the last point here is the last bullet point. We are interested in and required to report and determine eligibility based on the 6 months prior to the bankruptcy filing, and we don't count the month that we're in. So those are just some basics about income to watch out for. Continuing on with the initial consultation, I think it's our job, I believe I said it earlier, to get the information, explain what we think their options are, pros and cons, what the cost, if anything, would be, and answer their questions. And these are the basic options for people who have debt problems. And I don't go over all of these with everyone. For most people, some of these are just not a realistic option. There's no point in talking about them. For example, a lot of people call my office wanting to have a consultation to talk about settling their credit card debt. And what they don't realize, and I'll tell them when they come in, is, number one, you generally have to have a lump sum available to settle your credit card debts. If you owe, $60,000 worth of credit card debt, we might be able to settle it for 25 to 55 or 60 cents on the dollar. But that means you have to have tens of thousands of dollars ready to go. And if people had that, they wouldn't be here. The other thing is, even if they have the means, whether through a friend or a family member, there is a tax consequence to settling a debt. If you settle $60,000 worth of credit card debt for $20,000, then you can count on getting a 1099 the following January for the $40,000 that was written off. And I am not a CPA. I did not even stay at a Holiday Inn last night, but I do know enough to know that that can give rise to a tax consequence. And that tax consequence is not going to go away in a bankruptcy, at least not for 3 years. So sometimes people who settle their debts shoot themselves in the foot that way. But when I explain that to people, if they're persistent and they're interested in talking about settlements, that's the end of that. The only thing that I did not put on here and I want to touch on is there is the option of doing nothing. And I call that, we call that in this corner of the law, ducking and dodging. Judgments are good for 10 years. They can be renewed once for an additional 10 years under North Carolina law. So a judgment can follow you for 20 years, which is a very long time. This is a good state to live in if you cannot pay your debts on time and in full. Generally speaking, we do not have wage garnishment. You can look at NCGS 1-362 to better understand that. And further, this is a tenants by the entirety state. We give special protection to real estate in North Carolina that's owned by North Carolina residents. And what that means is garden variety creditors, mortgage companies, credit card debts, medical debts, and things like that. They can sue one spouse for that spouse's debts and get a judgment, but that judgment lien is not going to attach to the property. Likewise, the other spouse can have debts and be sued and have a judgment, and that judgment won't attach to the property. It's only judgment liens for joint debts that are going to attach to TBE property. So there's just a lot of reasons why it can be very difficult for creditors to collect from North Carolina residences. But if somebody calls in, for a bankruptcy consult or with a question about their debt, that's a pretty good sign that this is bothering them. And I tend to find that, unpaid judgments kind of affect quality of life. Even if you're judgment proof, it's not a great way to live. And you have to be very diligent about responding to your court paperwork so that you don't waive your exemption. So it's an example, and I should have put it on here, but it's not particularly useful in most of my consultations. I think in most circumstances that you're going to encounter in the pro bono world and that I encounter, a bankruptcy is the best way out of a bad situation. And I think that's what our job is to help the client understand the best way out of a bad situation, the least expensive in terms of dollars and the least expensive, emotionally and socially. And bankruptcy is usually a very good option. So what do you get to keep in a bankruptcy? People are worried they're going to lose their house, their car, their wages, and generally speaking, those fears are usually unfounded. Not always, we have to talk through those details, but as to what you get to keep in a bankruptcy and come out with, there are two basic categories of property. You get to keep your exempt property, and we have to look at the exemption laws there to determine that. That's the first category. And the other category of property that you get to keep is property that is not property of the bankruptcy estate. It just never comes into play. And that property is listed in section 541. Exemptions. We did away with debtors' prisons a long time ago. If you can't pay your debts on time and in full, like I said earlier, we don't take everything from you and make you live in the street. Everyone is allowed to keep basic property to be productive and move on. And if your client is a North Carolina resident and North Carolina exemptions apply to them, then these are the most common exemptions that you're going to see and you're going to talk to your clients about. Outside of the bankruptcy context, just in a lawsuit context, if you live in North Carolina, if this is your primary residence, then North Carolina exemptions apply to you. It's a little more nuanced under the federal bankruptcy code. We look to where the debtor has lived for the majority of the 2 years prior to the bankruptcy. And most of the time that's North Carolina. If it's not, then there's a little bit of a maze that we have to go through, and that's not worth going into today. So let's just assume for our purposes that North Carolina exemptions do apply. I have the most common ones listed here, and this refers to equity, these numbers. So by way of example, let's talk about the vehicle exemption. A debtor, whether it's a judgment debtor or a bankruptcy debtor, can have under North Carolina law and keep safe from their creditors one vehicle titled in their name with up to $3,500 in equity. So by way of example, if a client has a paid off car that's worth $5,000, we are going to claim their $3,500 vehicle exemption. And then we're going to drop down to number 9 on the slide here. We're going to use $1,500 of their wild card exemption. 1,500 plus 3,500 is 5,000. That vehicle is safe from creditors and cannot be taken. I tell my folks in initial consultations and after that, when we're talking about exemptions, that the way I think about this is there are various buckets of property, various buckets of exemptions, and we try to fit each piece of property into one of those buckets. But at the end of the day, if there is no specific bucket that protects that property, then we always have the $5,000 wild card, and we can use that on any one thing or any group of things that the client would otherwise lose. I noticed, again, preparing for today, I have a reference to a cheat sheet down here, and that's a recycled slide from a different program. I did not include the cheat sheet in your materials. If you want it, you're welcome to email me. Been talking too much, sorry. My email address is on the last slide here, and I'll be glad to email that to you, but I'm sorry I did not include that in today's materials.
Heather, we could also get it from you later and include it when we with the materials when we put up the video too.
I'd be glad to do that. That's a great idea. The other type of property that is safe in a Chapter 7 bankruptcy is property that is not property of the estate. And this is separate from exemptions, from state exemption laws. These are the most common ones that I run into and I think are useful to know today. In Chapter 7, your future earnings, meaning what you earn from your job or your personal services, is not going to be taken from the trustee. The day you file, that's a hard stop. We look backwards, but that you're not going to have to give that up. Whereas in Chapter 13, you're required to file a household income disclosure and a household budget disclosure, and you do have to pay over your leftover income for the next 36 to 60 months. That's not how Chapter 7 works. It's important to know that most retirement plans are protected in any chapter of bankruptcy, and I think that should make good sense. We as a society have decided that we would rather have you file and wipe out your credit card and your medical debt, but keep your retirement funds so that you can take care of yourself in the future. One of the things that bothers me about what I do, or is a downer, is people are so bound and determined to avoid bankruptcy that oftentimes they'll come in and tell me, when I ask about retirement, they'll tell me that they drained their 401k or their IRA and used it to make payments on credit cards and to try to settle their debts. And, that's just a shame, because if they had filed for bankruptcy, all of that would have remained intact. Social Security benefits are not property of the bankruptcy estate, and that protection is very broad. I think that's important for pro bono attorneys to understand. It includes benefits that you have not received. It includes, what you have received that's in your checking account or your savings account or in your wallet. It's just super broad. It's not something that people need to worry about losing, and it applies, to Social Security and old age benefits as well. These are some of the most common questions or issues that come up in initial consultations. And I'm sorry to take so much time on initial consultations, but it really is the chance to get very good information and to set the tone and make sure that you're making the right recommendation for folks. People's instinct particularly when they get sued or they get a judgment against them, is to transfer property. And that's usually the worst thing that you can do. It's unnecessary and it's very hard to undo. The thing that I see most commonly is, for example, a client will have a $6,000 vehicle that's paid for, and they'll get some collection paperwork and freak out and just transfer it over, title it into mom, dad, brother, sister, daughter, son, and keep driving it. That's a fraudulent transfer. That's a transfer of money or property for less than adequate consideration, less than fair market value. I tell folks, number one, if you're going to sell something or transfer something, it needs to be for fair market value. You need to sell it for what you would sell it to me for, a stranger, and you need to document that. But more importantly, it's not necessary. We have exemptions. You could protect that $6,000 vehicle using your exemptions. You're shooting yourself in the foot by transferring something because you can't exempt what you don't own. You will get credit again, at least if you can prove the income after you obtain your discharge order. You have the income to make payments. If you don't have income or sufficient income, it's going to be hard, just like it is for the rest of us. Bankruptcy stays on your credit report for 10 years, and it definitely will make your interest rate higher on your first credit card, your first debt, and it's going to make your limit lower. But I tell everyone to get a card or two, make a charge each month, pay it on time. And that way you're not paying interest. And every month that goes by with you making a payment on time, you're going to see your credit score rise. Most of our folks find that within 6 months to a year of discharge, their credit score is back to where it was before any of this ever started. Generally speaking, you are not going to be able to keep a credit card, and that includes cards that you've always paid faithfully on time and have no balance. We only report on a bankruptcy, give notice of a bankruptcy to your creditors. If you have a card and you're certain you don't owe them anything on the date of bankruptcy filing, we don't list them. They're not going to get notice from the bankruptcy court of the bankruptcy filing. However, all of the credit card companies subscribe to the credit bureaus, and the credit bureaus pick up bankruptcy filings within 24 hours and report them out. And your folks just need to know that their card's going to be canceled. And some people, that really bothers them. They just need to get used to not having a card for 4 months and getting new ones. But hopefully it's not too big of an issue. How public is this? It is a public record, just like the filing of a lawsuit or a deed or a marriage certificate. But you have to work pretty hard to find this. It's not going to show up just on a simple Google search. People generally need to have access to Pacer, the credit bureaus, or some kind of special newspaper that publishes, like the Mecklenburg Times publishes bankruptcy filings. It's just generally not going to happen. So I usually tell people there's not too much to worry about there. Will you lose your job? It's illegal to discriminate against people for filing for bankruptcy. But generally speaking, if somebody wants to fire you because of a bankruptcy, they'll just find some other reason to do so. In my experience and that of my peers, this is generally not an issue unless you have to have a particular security clearance at your job, or you have to be bonded because you're handling a lot of cash. In those circumstances, then this may very well affect your employment, and you should tread carefully. But unpaid debts and lawsuits are going to affect it as well. And as far as how long will all of this take, Chapter 7 bankruptcies, especially if there are no asset cases, are generally a pretty quick and straightforward process. It's usually about 4 months from the date of filing to the discharge order and to the closing of the case. Discharge orders and closing don't necessarily happen at the same time, and it can take longer than 4 months, but in the vast majority of cases, 4 months is how long it will take. I have a packet that I give to my folks. I'll email it to them if it's a virtual consultation. There is a short questionnaire that's a lot like the intake sheet, basic contact information, where to find you and who's in the house and income and employment. And we ask that again because oftentimes a year or two will go by between a consultation and then coming back to file. I have a pro bono client right now who first contacted me 18 months ago and has only now made his appointment to actually file. And there's a variety of reasons for that, why it can drag out, but we just need to make sure that we have the right information. I give them in the packet a list of documents that I need for them to get together and information and bring back or mail in to us or email in. That is Form 3. It's pages, it looks like 16 and 17 of the materials. Not all of that is going to apply to the client. A lot of clients don't own a business, aren't paying child support. I just tell folks, for the things that do apply to them, get those together. I tell them this is a lot like hiring a CPA or a tax preparer to prepare your tax returns. We'll do this for you. We just need a lot of information from you and your cooperation. Every individual or married couple filing for bankruptcy has to have completed a credit counseling class within the 180 days prior to the bankruptcy filing. Otherwise, they're not eligible to file and their case will be dismissed. Wherever you are living, check the Bankruptcy Administrator's website for your federal district. They maintain a list of approved agencies. You can't just go anywhere and get this credit counseling is for a very modest cost. And then best practices for the signing appointment. Typically it'll take us a few weeks to get everything ready, to get all the information and get the petition and the schedules and related documents ready. But when that good day finally comes, the goal of this is a few things, to explain to folks what's going to happen next, how it's going to work, how long it's going to take, answer any questions that they have, and just basically make sure that they're confident in what they're doing and understand it. Because once a Chapter 7 bankruptcy is filed, generally speaking, we can't take it back. It will not be dismissed. You're just going to have to see it through. And we want to make sure, that there are no surprises in terms of property or anything like that. The materials, my signing appointment checklist is in there. That's Form 5 on pages 23 to 25. And I just tell folks, I have this list here. It keeps me on track. It's a combination of the things that the law requires me to tell you, combined with things that in my experience, I want you to know, and I think will be useful to you. And I'll, kind of gently tell people, I've done this hundreds of times. I can anticipate nearly every question you're going to have. So if you could let me kind of do my sermon here, and hold your questions till the end, it'll make things go by more quickly for you and for me. But of course, if there's a burning question, fire away. A little bit of an error on this slide: keep a copy of the wet signature. No, you need to keep the original signature. That's what's required by the code and by most local rules. So in the old days, the only way that to authorize a bankruptcy filing was an original wetting signature, and we're obligated to keep those in our files for a long time. There are local orders pretty much everywhere now during this time of COVID that allow attorneys to sign for their clients if they have written permission to do so. I just shoot my folks an email and say, you've reviewed the attached petition and schedules and you believe it's correct. If you do, email me back and authorize me to sign it, and I'll sign this version and send you a copy. You can also use document signing software, but we are not that fancy. One thing to point out on that signing appointment checklist on the back is the right of offset. And I do want to touch on that so there are not any surprises. When you open a bank account virtually anywhere, buried in the fine print is you are agreeing to the right of offset. If you owe a debt to that particular financial institution and you don't make your payment on time, it gives them permission to go into your bank account without your knowledge or prior permission and take that payment out. And it even extends so far as to, if you file a bankruptcy and it's an unsecured debt, like a credit card, they can keep the entire balance that's on deposit up to the amount of the debt. And we certainly don't want that to happen. So I have preached this before the signing appointment, but I'll ask it one more time. And if it turns out, for example, they have $3,000 on deposit at Bank of America and they owe a credit card with a $5,000 balance, I'm going to send them out of here, tell them to go to Bank of America and take it out and come back, because we just don't want to lose that money. So for the uninitiated, that can be a nasty surprise. wrapping up here, I see we just have a few minutes left and I want to leave time for questions. These are the most common types of debts that survive a bankruptcy discharge, a Chapter 7 discharge. If anybody has any questions, I think we've covered this pretty well before. You can let me know, give me a call. And these are some of the things that you may have to do after a bankruptcy filing. This is probably really beyond what we can get into today. I just wanted to flag things for you. There's some information in the materials about that and some forms that may be helpful. I don't want to give the impression, that you file it and you're done. There is a hearing that has to be attended, and there's some paperwork that has to be done in most cases. That last bullet point there, if you're in the Western District of North Carolina, we have a custom that's peculiar to us. And I can email that form to you and explain it to you if you wind up in need. The next slide here is just some good resources. If you are dabbling in this area or want to dabble, I think these are very helpful resources. And I would also say that you really, if you're going to get into this, you need to have petition preparation software. You can get pro bono on a pro bono basis. You can tell these two companies, Jubilee and Next Chapter, that you're doing a pro bono case, and they'll allow you to use their software for free. And that really brings us to the end of our time. Are there any questions that you can see, Catherine? I don't think I can.
Yeah. Heather, I've got one question somebody sent to me, and thank you so much for this. And like we told everyone, all the attendees, we will share these presentations, so you'll have the information about the software and things like that you have access to, which is great. And Heather, I've learned a ton, so thank you so much. So the question, and I think we have time just for one, is this. So if you are interacting with a pro bono client and for a different matter, let's say a landlord tenant or anything that comes before you or might happen to somebody here who's at the presentation, and you are thinking that maybe bankruptcy is the route that they should be taking, it's not something that they came to you about, how do you suggest sort of broaching that subject with someone?
So I have two answers to that. I think it depends on where they came from. If they came from a pro bono agency, then I would reach out to the staff person who made the referral and tell them that I think a bankruptcy can help them, and ask if that's within their mission. They're all different. Some of the pro bono agencies here will only offer pro bono bankruptcy help to save a home. And it's that simple. If there's not a home at stake, they will not handle that case. But that varies from agency to agency. So I would start by contacting the agency and asking, if they offer that, and if so, can we make a referral to that? If that's not an option, then I would look for a pro bono attorney in the area. It's a hard ask to get someone to handle a Chapter 13 bankruptcy on a pro bono basis. I've done it once. I don't know that I would do it again. It's a 5-year commitment. And there's a part of me that feels like it's a 3 to 5 year commitment, but it's usually 5. There's a part of me that feels like if people can afford to make a payment for 3 to 5 years, they can probably afford to pay an attorney because it's a reasonable rate. But Chapter 7 bankruptcies, I think, are pretty easy sells. I'm not bashful about asking somebody if they can help someone on a pro bono basis. You could look around, you probably know someone in your area. You could call the lawyer referral service. There's a variety of ways, I think, to find someone to help. But those are my thoughts on that.
And I'm sorry, and I was going to say, I think what the question was getting at too was, what is it that the client might say to you that's triggering in your head that bankruptcy might be something they should be thinking about?
Okay.
To talk to the client.
Yeah, I mean, number one is, do they have a lot of debts that they can't pay? Do they have any debt that they can't pay on time and in full, whether it's your rent or your car payment? There's a repo. Is there a deficiency for an old repo? Are you behind on your mortgage? I mean, just look for basic not being able to pay debts on time and in full. Bankruptcy can provide a lot of relief for those various situations. That's what I would look for. And old judgments, old evictions, medical debt, if somebody's got a medical issue, they haven't had insurance coverage, they're applying for disability and they haven't found out, all those things are kind of classic hallmarks of maybe they should talk to a bankruptcy attorney.